Okay, let's unpack this. Here's a statistic that really grabbed my attention. The divorce rate for Americans over 50 has actually doubled since 1990.
Wow.
Think about that.
Yeah.
I mean, it's a massive demographic shift happening later in life.
It really is.
This trend, people are calling it gray divorce, it isn't just about the emotional side of ending a long marriage, right? It brings this unique and often really severe set of financial challenges.
Oh, absolutely.
Especially, as people are staring down retirement. Or maybe they're already there.
It's a huge reality check, isn't it? So many people picture their retirement years with a partner counting on those shared resources.
Right, the joint plan.
Yeah. And when a long marriage ends later in life, it just completely upends those plans. And the economic consequences are often, well, pretty significant and really hard to recover from.
Exactly. So today, that's what we're doing. We're diving deep into these unique American financial and retirement challenges that people face when they go through a gray divorce. We've sifted through quite a stack of sources, articles, research, data covering, well, everything from how Social Security benefits work after divorce,
which is super important,
to navigating those complex retirement plans, and even the sort of hidden damage of financial infidelity, plus figuring out healthcare later on.
Yeah, our mission really in this deep dive is to pull out the most crucial financial nuggets from all this material.
Right.
We want to help you kind of cut through the complexity and understand the real financial landscape of late life divorce, because the economic impact, it's substantial. It's often really underestimated.
Okay, let's get into what the sources are telling us about this trend itself first.
Well, what's fascinating here is just how rapidly gray divorce has become, a major thing. It's not just stories you hear. It's a really clear demographic trend.
Yeah.
Increasing divorce rates among couples aged 50 and older, and many of them have been married for decades. Sometimes you hear them called silver splitters.
Silver splitters. Huh, that term has a bit of a ring to it, doesn't it? Though the financial reality, as we're about to get into, is often less shiny.
That's putting it mildly.
Just how prevalent is this now? What do the numbers say?
Well, the numbers are quite stark, actually. As of 2023, roughly 1/3 of all divorces in the U.S. involve people over 50.
1/3.
Yeah. And like you said, the divorce rate for this specific age group, it doubled between 1990 and 2010.
Doubled.
That rate of increase is much, much higher than for younger groups during that same time. And get this. By 2013, the number of divorced people over 50 in the U.S. actually surpassed the number of widowed people in that same age group.
Whoa, wait, so more people over 50 were divorced than widowed by 2013?
Yeah, I mean, including people who got divorced or widowed at any age but were over 50 in 2013. It just shows a fundamental shift in later life demographics.
It is a surprising shift. It kind of goes against the older patterns where you'd expect widowhood to be more common than divorce later in life. And this isn't just happening in the U.S., is it?
No, you're right. Our sources point out that older couples are also driving the overall increase in divorce rates in the UK.
Okay.
In England and Wales, back in 2021, 1 in 4 divorces involved someone over 50. And between just 2005 and 2015, the number of men over 65 getting divorced went up 23%.
Wow.
And for women over 65, it jumped by a remarkable 38%. So yeah, this is definitely a widespread phenomenon in aging populations in developed countries.
It really points to bigger societal shifts happening. The sources mentioned some possible reasons for this rise, didn't they?
They did, yeah. A few factors are commonly cited. Increased human longevity, that's a big one.
Right. People are living longer.
Much longer. So marriages, if they last, could potentially go on for 50, 60, even 70 years.
Yeah.
And the idea of staying in an unhappy or, let's say, unfulfilling marriage becomes maybe less appealing when you think you might have another 2 or 3 decades ahead of you after a divorce.
Right. You've got more time to potentially build a different life, but changes the calculation, I guess.
Exactly. Then there's also the influence of, the baby boomer generation's cultural values.
Okay.
Often characterized by, a greater emphasis on personal fulfillment, individuality. And there's just less stigma attached to divorce compared to maybe their parents' generation. Divorce became more normalized during their lifetimes.
And a really crucial factor, especially for women, is increasing financial independence, right?
Absolutely. The sources do note that women are somewhat more likely to actually initiate divorce proceedings in this age group.
Interesting.
And this is often, it's helped by having their own financial resources, maybe work experience, or the ability to earn a living, even if, as we'll discuss, the financial reality after divorce is still really challenging.
It gives them options, agency maybe, that women in previous generations didn't have if they were more financially dependent.
Exactly. That financial dependence often kept people in marriages they might otherwise have left.
So, okay, the trend is clear, driven by a mix of things. But let's get to the absolute core issue highlighted in our sources,
Yeah.
the financial consequences. They're often described as, well, incredibly severe.
They truly are. Gray divorce commonly leads to significant economic hardship for both people, but there's a really stark difference in the impact depending on gender.
Okay.
Research cited in our sources, this was based on longitudinal data, found that women typically experience a staggering 45% decline in their standard of living after a gray divorce.
45%. That's nearly cutting your lifestyle in half. That sounds devastating.
It is. I mean, just imagine the adjustments you'd have to make with almost half the financial resources you had before to support your lifestyle.
Yeah.
Men also see a significant drop, don't get me wrong, it's about 21% on average. Still significant, but the impact is considerably less severe than for women.
21 versus 45. Big difference.
Huge. And it's not just about income or standard of living. Wealth takes a massive hit, too. Both women and men commonly see their accumulated wealth drop by roughly 50% after a gray divorce.
Okay, the 50% wealth drop, that kind of makes intuitive sense. You're splitting a lifetime of assets, basically. But why is the standard of living drop so much worse for women, that 45% number?
Well, it comes down to a mix of things, really. Expenses and earning potential.
Okay.
When one household splits into two, you effectively double your core expenses, housing, utilities, insurance, maintenance, all that stuff.
Right, 2 roofs instead of 1.
Exactly. What used to support one lifestyle now has to stretch to support 2 separate ones, and often less efficiently. And while the assets get split, future income earning capacity might be very different.
Ah, okay.
Women, on average, still tend to have lower lifetime earnings, maybe smaller pensions or less accumulated Social Security credits, often because of time taken out for caregiving.
Right.
So the income side of their post-divorce equation is often weaker than their male counterparts, even if the assets were split right down the middle.
And unlike younger couples who divorce, there's just so little time to recover financially at this age.
That's such a critical point. For people divorcing in their late 50s, 60s, or even older, the window to, earn more money, save aggressively, or really benefit from long-term investment growth to rebuild that lost wealth, it's significantly smaller.
Or maybe non-existent.
Or non-existent, exactly, especially if they're already retired. Retirement savings that get divided have very little time to regrow before you actually need to start drawing on them just to live.
And compounding this vulnerability, the sources highlight a really, really concerning statistic. Nearly half, 48% of U.S. households headed by someone age 55 and older lack any kind of retirement savings.
Isn't that incredible?
So for a huge chunk of this population, they're basically starting from zero, even before the financial shock of divorce hits.
That statistic is just incredibly sobering. It means divorce is hitting a significant number of older adults when they're already in a financially precarious spot.
Yeah.
And beyond just personal finances, divorce can also severely impact the potential inheritance for adult children.
Oh, that's a good point.
Yeah, the combined wealth that might have been passed down is reduced. And importantly, if a former spouse remarries, their new spouse often becomes the primary beneficiary,
Right.
which can potentially reroute assets away from the children of that first long marriage.
That's a really important, often overlooked consequence for the game. What about the marital home? That's usually a huge asset, maybe the biggest one for many couples.
Absolutely. The house, which, might have been paid off or was central to the retirement plan, often has to be sold.
Right.
The equity gets split, sure, but people sometimes forget about all the costs involved in selling, prepping the house, realtor fees, closing costs, plus you've still got ongoing utility bills, maybe mortgage payments, until that sale actually goes through.
Yeah, it's not just free money appearing.
Not at all. It's managing a complex, often costly transaction while you're already dealing with everything else.
And thinking about older age, a spouse often represents a significant source of, informal long-term care, right?
No, that's a crucial point for later life planning. The loss of a spouse means losing that potential live-in caregiver down the road.
Yeah.
This increases the need to think about expensive long-term care insurance, or it might mean relying more heavily on adult children for help as health declines.
Which adds stress to the next generation.
Exactly. And from a broader societal view, the sources note this trend increases demand for social services, things like public transportation, affordable housing, professional caregiving services. It ripples outwards.
So, okay, the financial consequences are profound. They hit income, wealth, future plans, even family inheritance and caregiving needs. But they're also critical safety nets and legal structures people really must understand to protect themselves. One of the biggest involves Social Security benefits.
Yes, this is such a vital area, and one where many people, particularly women, are just unaware of their rights. They're basically leaving money on the table.
Really?
Yeah, our sources cited a Mass Mutual survey. It revealed that more than 4 in 10 Americans nearing retirement, so over 40%, don't know that divorced individuals can collect Social Security benefits based on an ex-spouse's earnings record.
Wow, 40% are unaware. That's a huge nugget of information right there for anyone listening who might be in this situation.
Absolutely critical. It could be thousands of dollars a year.
What are the biggest fears people have about, claiming on an ex's record? Why wouldn't they do it if they knew?
Well, the biggest concerns, especially among women, tend to revolve around notifying the ex-spouse.
Okay.
They worry their ex will be angry, or that the Social Security Administration, the SSA, will actually tell the ex that they've filed. And probably most importantly, they worry that claiming will somehow reduce their ex's own Social Security benefit amount.
And the key insight here, the big takeaway, is that those fears are largely unfounded, correct?
Precisely. This is so important to understand. The Social Security Administration does not notify your ex-spouse when you file for divorced spouse benefits.
Okay, good to know.
It's a private process between you and the SSA, and your claim does not reduce your ex-spouse's benefit amount, period.
Okay.
It also doesn't affect the benefits of any other current or former spouses who might also be eligible to claim on that same work record. Social Security can and does pay multiple benefits simultaneously based on a single worker's history.
That's a massive relief, I imagine, for many people. It removes a major emotional barrier.
Right.
So why does Social Security even allow this? What's the thinking behind it?
The rationale, as our sources explain it, is basically rooted in the view that a long-term marriage is a partnership.
Okay.
Both people are seen as contributing to the household and, importantly, to the ability of the main earning spouse to build up their work record, even if one spouse maybe wasn't employed traditionally for some periods, perhaps due to caregiving.
Right, recognizing that non-paid contribution.
Exactly. So divorced spouse benefits are really just an extension of the benefits married couples already receive. They're intended to provide some equity. They ensure that a partner in a long-term marriage isn't financially penalized just because the marriage ended in divorce instead of, say, death. It recognizes the value of that shared history.
That framing makes a lot of sense. So
Yeah.
if you're listening and you were in a long marriage that ended in divorce, what are the specific eligibility criteria? How do you know if you can claim benefits based on a living ex-spouse's record?
Okay, there are 5 main requirements you generally need to meet.
Okay.
1, you have to be at least 62 years old. That's the earliest claiming age.
62, got it.
2, the marriage must have lasted for at least 10 years. This is often called the 10-year rule, key threshold.
10 years, okay.
3, your ex-spouse must be qualified for Social Security, retirement, or disability benefits based on their work history. Now, they don't necessarily need to have started collecting their benefits yet, but they have to be eligible.
Right, they just need enough work credits.
Exactly. 4, your own retirement benefit, based on your own work history, must not be higher than the benefit you would get based on your ex-spouse's record.
Okay.
If you're eligible for both, Social Security will automatically pay you the higher of the 2 amounts. You don't get both added together.
Right, you get the bigger one.
You get the bigger one. And 5, you must currently be unmarried. Generally, if you remarry, your eligibility for benefits on a living ex's record ends,
Okay.
unless that later marriage itself ends through death, divorce, or annulment.
That 10-year rule seems pretty clearly designed to capture those longer-term partnerships you were talking about.
Exactly. It's seen as a way to recognize a significant shared life and contribution, distinguishing it from shorter marriages. And importantly, your former spouse's marital status, whether they remarry or not, has absolutely no effect on your eligibility for divorced spouse benefits.
Okay, that's good to know too. So, if you meet those criteria, 62 plus menage, 10-year marriage, X is eligible, your own benefit isn't higher, and you're unmarried, how do you actually apply? What's the process like?
You've got options. You can apply online through the SSA website, you can apply by phone, or you can go in person to an SSA office.
Okay.
If you go in person, scheduling an appointment is definitely recommended. You'll need to gather quite a bit of paperwork.
Like what?
Things like your birth certificate or other proof of age, proof of U.S. citizenship or lawful residency. Your Social Security card helps here your marriage certificate and, critically, your final divorce decree.
Got to have that divorce decree.
Absolutely. They might also ask for tax records, like W-2s or self-employment tax returns from past years. You'll typically need to provide originals or certified copies, but the SSA will return them to you.
So the lesson is, keep those divorce decrees and marriage certificates somewhere safe, even if the divorce was decades ago.
Absolutely vital. Our sources really stress this. Trying to track down a marriage certificate or a divorce decree years, maybe even decades later, can be a real challenge.
Yeah, I can imagine.
Getting those documents and storing them securely while communication with your ex is still possible, even if it's strained, can save you a lot of headaches down the road when you're ready to apply for benefits.
Good advice. Okay, so once you're eligible and you apply, how much can you actually expect to receive based on your ex-spouse's record?
Well, the amount depends critically on your age when you decide to claim those benefits.
Okay.
If you claim at the earliest possible age, which is 62, you'll receive 32.5% of your ex-spouse's full retirement benefit amount. That's the amount they'd get at their full retirement age.
32.5% of 62.
Right. But that percentage increases for each month you delay claiming up until you reach your own full retirement age, or FRA.
Which varies depending on when you were born, right?
Exactly. For anyone born in 1960 or later, their FRA for retirement benefits is 67. If you wait until your own FRA to claim divorced spouse benefits, you'll receive the maximum amount, which is 50% of your ex-spouse's full retirement benefit.
50% if you wait until your full retirement age.
Okay. And just to be absolutely crystal clear again, because this seems to be a major point of confusion, this 32.5% or up to 50% that you receive does not reduce your ex-spouse's benefit amount in any way.
Correct. Cannot emphasize that enough. Your benefit is paid independently based on their record. It takes nothing away from them or their current spouse if they've remarried or any other eligible ex-spouses.
Okay, what if my ex-spouse is eligible for Social Security based on their work, but they haven't started collecting their own benefits yet? Maybe they're delaying until 70. Can I still claim on their record?
Yes, that's possible, but there's a specific condition attached.
Okay.
You can claim benefits if your ex is eligible but hasn't filed yet, but only if your divorce occurred at least 2 years prior to the date you file for benefits.
A 2-year waiting period after the divorce.
Right. If your ex-spouse is already collecting their benefits when you apply, then that 2-year waiting period is waived. You don't need to worry about it. Got it. And can my ex put something in the divorce decree or do anything legally to stop me from applying for these benefits? Like, can they make me waive my right?
No, that's another key point our sources confirm. Social Security does not recognize or enforce any clauses in private divorce agreements that attempt to waive or prevent a former spouse from applying for benefits based on the other's record. Yeah. It's a federal right granted to eligible divorced individuals under the Social Security Act, and you cannot sign it away in a divorce settlement.
That's really important protection. How would someone even find out how much their ex's full benefit amount is so they can estimate their potential divorced spouse benefit, especially if things aren't, amicable?
Yeah, that can be tricky. If you are on good terms, the easiest way is just to ask your ex for their full retirement age benefit amount. They can find it on their annual Social Security statement or by logging into their online My Social Security account.
Okay.
Then you can use the calculators on the SSA's website to estimate your potential benefit. If asking isn't feasible, you can contact the SSA directly.
What do you need to tell them?
If you provide proof of your marriage certificate and your divorce decree, along with identifying information for your ex, usually their Social Security number, date and place of birth, and maybe their parents' names, the SSA can typically look up their record and give you an estimate of the maximum benefit you could receive based on their record. They won't tell you the ex's exact benefit, but they'll tell you what your potential benefit could be.
Okay, that's helpful.
Yeah.
Now, years ago, there was this strategy, I think it was called a restricted application, where someone eligible for both their own benefit and an ex-spouse benefit could, choose to take just the ex-spouse benefit first.
Right.
And let their own retirement benefit continue to grow, maybe until age 70 before switching. Is that still an option for most people?
This is an area where the rules changed significantly because of a budget law passed back in 2015.
Okay, so it's different now.
It is. For most people born after January 1st, 1954, that restricted application strategy for claiming only spousal or ex-spousal benefits while delaying your own retirement benefit has been phased out.
So what happens now?
Now, if you are eligible for benefits based on both your own work record and your ex-spouse's record, meaning you are duly entitled when you apply for Social Security, the SSA considers you to be applying for all benefits you're eligible for at that time.
Okay.
And they will simply pay you the single highest amount you're eligible for automatically. You generally don't get to pick and choose anymore to maximize growth in that specific way.
So no more strategically claiming just the ex-spouse benefit first for most people divorcing now.
Correct, with very limited exceptions. You might still be able to file a restricted application for only spouse or ex-spouse benefits if, say, you are caring for a child from the marriage who is under age 16 or disabled, or potentially if you are also entitled to Social Security Disability Insurance, SSDI. But for most retirees, you're deemed to have filed for both, and the SSA just pays the higher amount.
Okay. What if you're claiming these divorced spouse benefits before your full retirement age and you're still working? Does your benefit get reduced?
Yes, just like regular retirement benefits claimed early, divorced spouse benefits are subject to Social Security's earnings test if you claim them before you reach your full retirement age and continue to work.
Okay.
If your income from work goes over certain annual thresholds, your benefits may be temporarily reduced. For example, in 2025, if you won't reach your full retirement age that year, you lose $1 in benefits for every $2 you earn over $23,400.
Ouch.
The rules are a bit more generous in the year you actually reach your FRA, but yeah, there's a limit.
In that earnings test, that penalty, it stops completely once you hit your full retirement age.
Yes, that's another key point. Once you reach your full retirement age, you can earn as much as you want from work, and your Social Security benefits will not be reduced at all. And actually, any benefits that were withheld before your FRA because of the earnings test aren't truly lost. They're actually credited back to you over time in the form of slightly higher monthly payments once you reach FRA. So you get it back eventually.
Okay. That's good to know. So that covers claiming on a living ex-spouse. What about if your ex-spouse has passed away? Are there survivor benefits for divorced people?
Absolutely, yes. And this is another really critical safety net, often providing a higher benefit. Divorced individuals can receive survivor benefits based on a deceased former spouse's earnings record.
Oh.
These benefits can range from 71.5% up to 100% of what your late ex-spouse's benefit was or would have been, depending on your age when you claim the survivor benefit.
So potentially a much higher percentage than the 50% max for a living ex.
Ah.
What are the eligibility rules for these survivor benefits? Are they the same?
They're similar, but there are some really key differences you need to know.
Yeah,
You
okay.
generally still need to meet that 10-year marriage duration requirement.
Right, the 10-year rule still applies.
Usually. The minimum claiming age is typically 60, so a bit earlier than for retirement benefits. Or you can claim as early as age 50 if you are disabled.
60 or 50 if disabled. Okay.
Now, a significant difference here. The 10-year marriage rule and those age rules, 60-50, can actually be waived if you are caring for your deceased ex-spouse's child who is under age 16 or disabled, and that child is receiving benefits on the ex's record.
Ah, so the child receiving benefits is key there.
Yes. And another huge difference relates to remarriage.
Okay, how does remarriage affect survivor benefits? Does it prevent you from collecting like it usually does with benefits on a living ex?
This is where the rules are much more favorable for survivors. With survivor benefits, you can remarry and still collect benefits on your deceased ex-spouse's record, provided that the remarriage occurs after you turn age 60.
After 60.
Or after age 50 if you are disabled. If you remarry before those ages, you generally lose eligibility for survivor benefits on the deceased ex's record. But remarriage after 60 or 50 if disabled does not impact your eligibility. That's a critical distinction.
Yeah. That is a huge detail. Being able to remarry after 60 and keep survivor benefits from a long-term prior marriage. And you said the benefit percentage is higher too.
Yes, survivor benefits are generally designed to provide a more substantial replacement of the deceased person's income. As I mentioned, they range from 71.5% if you claim right at age 60, or 50 if disabled, up to 100% of the deceased ex's benefit amount if you wait until your full retirement age for survivors, which, confusingly, can be slightly different from the FRA for retirement or spousal benefits.
Okay, so potentially 100% of the ex's benefit. Now, what about that restricted application strategy? Can you use that for survivor benefits, choosing to take the survivor benefit while letting your own grow?
Yes. This is the main area where that restricted application strategy still exists for people born after 1954.
Okay.
Surviving ex-spouses can still file a restricted application. This allows you to choose, for example, to take the survivor benefit first, maybe at a reduced rate if you claim before your survivor FRA, while letting your own retirement benefit based on your work history continue to grow, potentially all the way up to age 70.
Okay.
At that point, you could switch over to your own maximized retirement benefit if it turns out to be higher than the survivor benefit. This gives you really important flexibility to maximize your total lifetime income.
That's fantastic flexibility for surviving ex-spouses. How do you apply for survivor benefits? Is it the same process?
Slightly different here. You generally can't apply online for survivor benefits. You usually need to apply either by phone or by visiting a Social Security office in person.
Okay, phone or in person?
Now, if you were already receiving divorced spouse benefits on your ex's record before they passed away, the SSA should automatically convert your benefit to the higher survivor benefit amount once the death is reported to them. You shouldn't need to reapply in that case.
Okay. Do we have a sense of how many people are actually using these divorced spouse and survivor benefits?
We do. Looking at the most recent data cited in our sources from December 2023, it's really clear who primarily relies on these benefits. Women make up a remarkable 95% of all individuals receiving Social Security spousal or survivor benefits based on a divorced partner's record.
95% are women. Wow.
The numbers are pretty substantial, too. You had over 161,000 people receiving benefits as divorced spouses of retired workers, and their average monthly benefit was around $960.
Okay.
Another 11,000 were divorced spouses of disabled workers, averaging about $430 a month. Then on the survivor side, over 429,000 divorced individuals were collecting survivor benefits on a deceased ex's record, and their average monthly benefit was much higher, around $9,866.
So nearly $1,900 a month on average for divorce survivors.
Yeah, I mean, these aren't necessarily full incomes on their own, but $960 or almost $1,900 a month represents a really crucial piece of financial security for hundreds of thousands of older Americans, especially women.
Those statistics really drive home just how vital these benefits are, particularly for women who, like you said, often have less robust individual earnings histories. It's a fundamental safety net that people absolutely need to know about and use if they're eligible.
Absolutely. It can really make the difference between struggling financially in retirement and having at least a degree of stability.
Okay, so Social Security is one major complex puzzle piece. Another, and arguably even more complex piece, is dividing the actual retirement plans. You know, the 401ks, pensions, IRAs. This isn't like just splitting a joint bank account, is it?
Not at all. This is where things get really technical and require very specific legal tools. Dividing retirement assets acquired during the marriage is obviously a critical part of any divorce, especially a gray divorce where these might be the largest assets.
Right.
And it's governed by totally different rules than other assets like a house or a brokerage account. The most common legal instrument you need for private employer-sponsored retirement plans is called a QDRO.
QDRO. Okay, we hear that acronym thrown around a lot in divorce discussions. What exactly does it stand for, and why is it so essential?
Okay, QDRO stands for Qualified Domestic Relations Order.
Qualified Domestic Relations Order.
Right. It's a special type of court order that basically carves out and assigns a portion of a retirement plan participant's benefit to someone else, usually a former spouse, but sometimes a child or other dependent. This happens as part of a divorce or sometimes for child support or spousal support.
Why do you need this specific order?
You need one because federal law, specifically ERISA, the Employee Retirement Income Security Act of 1974, generally prohibits a plan participant from assigning their benefits to someone else. It protects the retirement funds.
Oh, okay.
But the Retirement Equity Act of 1984 created the specific QDRO exception just for domestic relations matters, divorce, support, etc. So think of the QDRO as the special legal key that unlocks that retirement account and allows the plan administrator, the company managing the 401k or pension, to legally divide it according to the court order.
So it's a necessary legal document that essentially overrides the standard rules, but only for divorce and related matters.
Exactly. It's what makes the division permissible under federal law and, crucially, recognizable and acceptable by the plan itself. But, and this is a really critical point, our sources emphasize QDROs are specifically for those ERISA-governed plans.
Which are mostly private sector plans.
Right. Primarily your private company, 401k, profit-sharing plans, and traditional defined benefit pensions. If your ex-spouse worked for the government or the military, you're going to need a different type of order.
Oh, okay. Different orders. Like what? This gets complicated fast.
It does. The type of plan dictates the specific order required. So for federal government civilian plans, like CSRS or FERS,
Right, they're federal employees.
you need something called a court order acceptable for processing, or a CO.
COEP, got it.
Then there's the Federal Thrift Savings Plan, the TSP, which is like the 401k for federal employees and military members.
Right.
That requires a retirement benefits court order, or RBCO.
RBCO for the TSP. Okay.
Military retired pay, that's divided under different federal laws using a military pension division order, or MPDO.
MPDO for military pensions.
And then state and municipal retirement plans, like for teachers, police officers, state workers, they're governed by individual state laws and local rules, not ERISA.
So each state could be different.
Potentially, yes. The order might just be called a domestic relations order, DRO, but the specific rules, what can be divided, how it's divided, they can vary greatly by state and by the specific plan. However, many state or city-defined contribution plans, like 401AS, 403Bs, or 457 plans, often are subject to QDROs because they fall under similar tax code sections.
Okay, that's a lot of acronyms already. What about IRAs?
Yeah.
Individual retirement arrangements. Surely those are simpler.
Handled differently again. IRAs are not subject to ERISA or QDROs. They're divided under a specific section of the Internal Revenue Code, Section 408D. While they don't technically require a QDRO, the IRA custodian, the bank or brokerage holding the IRA, might still require some form of domestic relations order, DRO, or specific transfer instructions written into the divorce decree itself to ensure a clean, tax-free transfer between the former spouses. It's called a transfer incident to divorce.
Still need the paperwork right, basically.
Yeah.
What about really complex plans like maybe executive deferred compensation or SERPs?
Yeah, those non-qualified plans are often the trickiest. They rarely have formal division mechanisms like QDROs. They aren't typically qualified plans under ERISA or the tax code.
So how do you divide those?
In those situations, the divorce settlement usually needs to create workarounds. Typically, the employee spouse contractually agrees in the settlement to pay a portion of the future benefit directly to the former spouse when they receive it themselves.
Ah, so the ex-spouse has to rely on the participant to pay them later.
Exactly. Which involves higher risk for the former spouse receiving the funds. They're relying on the ex-spouse's future cooperation and ability to pay, not getting a direct payment from the plan administrator.
Definitely riskier. So understanding the type of plan is clearly the absolute first step.
It dictates everything: which legal document you need, what the rules for division are, and the two broad categories of plans you're usually dealing with are defined contribution plans and defined benefit plans.
Okay, refresh my memory. Defined contribution is like a 401k, right?
Yeah.
Where you have an actual account balance that goes up and down with the market.
Exactly right. Defined contribution plans, 401ks, 403Bs for nonprofits, profit sharing plans, TSP, they're individual accounts. Contributions go in, maybe from you and your employer, and the value changes based on how the investments perform. Defined benefit plans, on the other hand, are your traditional pensions.
Right, the old school pensions.
Yeah. They promise a specific future monthly benefit, usually based on some formula tied to your salary history, your years of service, and your age at retirement. There isn't really an individual account balance you can point to in the same way while you're still working.
Okay, got it. So once the QDRO or the COEP or the RBCO or whatever order is needed gets approved and finalized, how soon can the alternate payee, that's usually the former spouse,
Right.
get their share?
Right, the alternate payee. For defined contribution plans, like the 401k, once the QDRO is formally reviewed and qualified or accepted by the plan administrator, the alternate payee can usually get their awarded share pretty quickly, as soon as the plan can process the transfer.
And what can they do with it?
They typically have options. They can usually roll it over directly into an IRA in their own name, which keeps the money tax deferred, or in many cases, they can choose to take a cash distribution.
Okay. What about defined benefit pensions, since it's a future stream of income?
Those are different, yeah. The timing of when the alternate payee can start receiving benefits from a pension often depends on how the QDRO, or relevant order, is drafted, specifically which division method it uses.
Division method.
Yeah, there are generally two main ways. If the QDRO uses the separate interest method, the alternate payee's share is calculated as like their own little mini pension based on the marital portion of the participant's accrued benefit.
Okay.
With a separate interest, they can often start drawing their portion as soon as the participant reaches their earliest retirement eligibility age under the plan, even if the participant decides to keep working. The alternate payee's benefit is based on their own lifetime.
Okay, so they can get it sooner, potentially. What's the other method?
The other main one is the shared payment method. Here, the alternate payee is awarded a specific percentage or dollar amount of the participant's actual monthly benefit payment. So under shared payment, the alternate payee can only start receiving payments when the participant actually retires and begins receiving their pension. And the payments usually stop when the participant dies, unless survivor benefits were also awarded.
Wow, that timing difference between separate interest and shared payment is huge. That's a major negotiation point in the divorce, I bet.
Absolutely critical. What about taxes on these divided retirement funds? Who pays?
Good question.
This is actually a key benefit of using a proper QDRO or similar order. When an alternate payee, who is a spouse or former spouse, receives a distribution directly from the retirement plan that's subject to the order, that distribution is generally taxable to the alternate payee, not the original participant.
Okay, so the tax liability shifts.
It shifts. The plan will issue an IRS form 1099-R to the alternate payee, reporting the income. Now, if the alternate payee is a child or other dependent, the tax liability usually stays with the participant.
Okay. And you hear about an exception to the early withdrawal penalty with QDROs.
Yes, this is another really critical detail that often gets missed or misunderstood. A distribution received directly from the plan subject to the QDRO by an alternate payee who was the spouse or former spouse is specifically exempt from the usual 10% early withdrawal penalty.
Even if they're under age 59 and a half.
Even if they're under 59 and a half. This is a specific exception carved out for QDRO distributions to former spouses. However, and this is crucial, if that same money is first rolled over into an IRA or another plan in the alternate payee's name,
Great.
and then they take a distribution from that IRA or new plan before they reach age 59 and a half, the 10% early withdrawal penalty will generally apply to that subsequent distribution from the new account. The QDRO penalty exception only applies to distributions taken directly from the original plan subject to the QDRO.
Wow. Okay, so if you need penalty-free access to funds from, say, a 401k awarded via QDRO before you're 59 and a half, you have to take it straight from the 401k plan itself, not roll it over first.
Correct.
But then you'd pay income tax on it immediately and lose all the future tax-deferred growth on that money. That's a really significant financial decision with big trade-offs.
Exactly. It requires very careful consideration, probably professional advice, to understand the short-term versus long-term implications. Another complex area is how you actually handle dividing multiple retirement accounts, or maybe offsetting retirement assets against other things, like the house.
Yeah, can't you just, add up the value of all the retirement accounts, say they're worth $500 K total, and then give one spouse 250 Ks worth of those accounts, and the other spouse gets, say, 250 Ks more equity from the house to make it even? Seems simpler.
Parties can agree to do that, and sometimes they do, especially if they want to save on the cost and hassle of preparing multiple QDROs for smaller accounts.
Right.
However, our sources really highlight that the only way to absolutely guarantee that both parties equally share in the investment gains and losses on their respective portions after the divorce agreement is signed, but before the money is actually moved, is to divide each defined contribution plan separately via its own QDRO, allocating a specific percentage or dollar amount from each plan.
Why is that?
Because if you offset, say, you get the 401k, and I get extra house equity, you accept the risk that the 401k might go way up or way down in value between the date you agreed on the values and the date the divorce is final and the assets are actually transferred. The house equity, on the other hand, is relatively stable, so offsetting introduces market risk inequality. Dividing each plan ensures you both ride the market waves together on your awarded shares until the split happens.
That makes sense. And valuing defined benefit pensions for offsetting sounds even harder.
It is incredibly complex. Pension valuations rely on actuarial assumptions about future interest rates, life expectancy, retirement dates, things that are just estimates.
Right.
Different actuaries using different assumptions can come up with different present values for the same future pension promise. So, offsetting a defined benefit pension against a hard asset like cash or house equity, or even against another pension with different assumptions, is generally not recommended by experts.
Too much guesswork involved.
Too much guesswork, potential for unfairness. It's usually much cleaner and safer to divide each pension separately using the appropriate court order, awarding a share of the future benefit stream itself.
Okay. Could you sort of walk us through the general process for actually getting a QDRO done? It sounds like it's definitely not a quick thing.
No, it definitely takes time and precision. It's not something done overnight. The typical process involves several key steps.
Okay.
First, obviously, the parties have to reach an agreement on how the specific retirement plan will be divided as part of their overall divorce settlement. What percentage or dollar amount goes to the former spouse.
Step 1. Agree on the split.
Right. Step 2. Gather information specific to that plan. Plans often have their own model QDRO language they prefer, specific guidelines, procedural requirements. You need the summary plan description, SPD, for the plan.
Like the plan's rules.
Exactly. Step 3. Someone, usually an attorney or a QDRO specialist, drafts the actual QDRO document using language that meets both the legal requirements and the specific plan's rules. Often, this draft is submitted to the plan administrator for a preliminary review or conditional pre-approval before it goes to the judge.
Smart. Check with the plan first.
It saves time and avoids rejection later. Step 4. Once the draft is agreed upon by both parties and maybe gets that pre-approval nod from the plan, the QBRO is formally signed by the judge and entered by the court, usually at the same time as the final divorce judgment or decree.
Okay, becomes official court order.
Step 5. A court-certified copy of that signed QDRO is then sent to the plan administrator for their formal qualification review. They check it against the plan documents and federal law, ERISA.
The plan gives the final okay.
Right. Step 6. The plan administrator notifies both parties when they receive the order, and then again, once they make their determination, either it's qualified or not qualified. If it's a not qualified, they'll usually say why, and you have to fix it and resubmit.
Right.
If it is qualified, the alternate payee then receives official notification of their rights, their share, and instructions on how to actually claim or roll over their funds.
Wow, that's a multi-step process involving lawyers, the court, and the plan administrator. Definitely needs careful handling. What are the typical kinds of benefits awarded via QDRO?
Well, it depends on the type of plan. For defined contribution plans like 401ks, it's usually a portion of the account balance as of a specific date, plus or minus any investment gains or losses on that portion between the valuation date and the distribution date. Key things to address in the QDR drafting include how to handle any outstanding participant loans, should the loan balance be included or excluded from the divisible amount, and how to account for things like employer contributions that might be deposited after the divorce date but were earned during the marriage.
Lots of details. What about for defined benefit plans, the pensions?
For pensions, the QDRO typically awards a portion of the participant's accrued benefit. That's the basic monthly pension amount earned during the marriage. But crucially, a well-drafted QDRO must also address any potential ancillary benefits.
Ancillary benefits, like what?
Things like cost of living adjustments, COLAs, that might increase the pension payment after retirement, or early retirement subsidies or supplements the plan might offer. The QDRO needs to specify if the former spouse gets a share of those too, and most importantly, it needs to address survivor benefits.
Right. Survivor benefits from a pension seem absolutely huge for a former spouse's security, especially if the participant spouse dies first.
Absolutely vital. The QDRO must clearly state whether the former spouse is being designated as the surviving spouse for purposes of receiving a share of the qualified pre-retirement survivor annuity, QPSA, if the participant dies before retiring.
Okay.
And/or a share of the qualified joint survivor annuity, QJSA, if the participant retires with the survivor benefit and the shared payment method is used.
And if the QDRO doesn't mention survivor benefits?
Failure to properly address survivor benefits in the QDRO can mean the former spouse gets nothing from the pension after the participant dies, even if they were receiving monthly payments while the participant was alive. The survivor benefit rights can be lost entirely if not secured in the QDRO.
That's a potentially devastating mistake. It really sounds like knowing the intricate details of the specific plan you're dealing with is absolutely non-negotiable.
Cannot be stressed enough. Our sources strongly emphasize this. Even plans of the same type, like two different companies' 401k plans, can have different rules, different distribution options, different ways they interpret QDRO language.
Yeah.
Public sector pensions, like for state employees, operate under vastly different rules than private ERISA plans. Plans for churches or certain nonprofits might have unique rules or exemptions. Getting the QDRO or the COAP or the RBCO drafted correctly depends entirely on knowing that specific plan's requirements and preferred language.
Okay. What if a pension is already being paid out when the couple decides to divorce? Can you still divide it?
Yes, but it adds another layer of complexity. If a defined benefit pension is already in pay status, especially if the couple was married when the participant originally retired, you need to figure out what form of payment was elected back then.
Okay.
ERISA plans typically require by default that a married participant take their pension as a joint and survivor annuity, which automatically provides a continuing benefit to the spouse after the participant dies, unless the spouse gave written, notarized consent to waive that survivor protection.
Right.
So if they divorced after retirement started, the QDRO needs to address how that existing payment stream is divided. And critically, if for some reason the former spouse cannot receive a survivor benefit directly from the plan upon the participant's death, maybe because a single life option was chosen years ago or the QDRO wasn't done right, the divorce settlement might need to address that lost security.
Ow.
Sometimes by calculating the value of that lost survivor benefit and requiring the participant to maintain a life insurance policy on their life, with the former spouse named as beneficiary, to replace the lost pension income if the participant dies first.
Wow. Okay. And you also need a plan for how the former spouse will get their share of the monthly pension payment during the time it takes to get the QDRO fully processed and qualified by the plan, right?
Yeah.
Because that could take months.
Yes, absolutely. That transition period needs to be covered explicitly in the divorce settlement agreement. Often it's handled through temporary spousal support payments equal to the expected pension share, because it can easily take 6 months or more for the QDRO process to complete and for the plan to start sending payments directly to the former spouse.
Okay. You also mentioned calculating the marital portion of the benefit earlier. That sounds like it could be complicated too.
It definitely can be. For defined contribution plans, it's usually a bit more straightforward. You're typically dividing the contributions and the growth that occurred between the date of marriage and the date of separation or divorce. Though even there, you have arguments about how to treat growth on premarital funds.
Okay.
For defined benefit pensions, it's more complex. States often have different approved methods or formulas for determining the marital share of a pension earned over a long career that might span before, during, and after the marriage. Common methods have names like prospective coverture, accrued coverture, or sometimes a tracking method.
And the method used matters.
Oh, significantly. The specific formula or method used to calculate the marital portion can result in very different dollar amounts for the former spouse's share. It's a key point for negotiation.
Given all this complexity, the different types of orders, the need for plan-specific language, the valuation methods, survivor benefits, tax implications, marital portion formulas, it sounds like drafting these QDROs and other orders is incredibly specialized work. This is not a DIY project.
Absolutely not. Our sources are very, very clear on this. QDROs and these similar orders are highly technical legal documents. Mistakes are incredibly easy to make, even for attorneys who don't regularly specialize in this specific area of law.
Right.
These documents need to be drafted with precise legal language that meets both the Internal Revenue Code, ERISA, or state law requirements, and the plan's own idiosyncratic rules. Trying to use a generic form or having someone inexperienced handle it is really risky.
What could go wrong?
Errors could lead to the order being rejected by the plan, significant delays, unexpected tax consequences, or, worst case, the former spouse losing out entirely on their rightful share of a critical retirement asset. And often these mistakes are very difficult or even impossible to fix years later after the divorce is final.
Wow.
So it's strongly, strongly recommended to use an attorney who specializes in QDROs or a dedicated QDRO preparation service that routinely prepares these orders and, importantly, carries appropriate liability insurance for this work.
So getting expert help here isn't just a good idea. It's pretty much essential to avoid potentially disastrous and irreversible mistakes with retirement funds.
It's absolutely critical. Don't skimp on expertise here.
Okay, let's shift gears a bit, moving from the legal structures to something more behavioral, but something with equally severe financial consequences, particularly in the context of gray divorce, financial infidelity.
Yes, this is a significant and often hidden threat, especially when discovered later in life during a divorce. Financial infidelity, just to be clear, is defined as deception about money within a marriage.
So it's more than just arguing about money.
Right. It's not just disagreeing on spending habits. It involves purposeful secrecy and dishonesty. Things like hiding spending, keeping secret bank accounts or credit cards, hiding debt, borrowing money without the spouse knowing, or making significant financial decisions unilaterally that negatively impact the couple's shared financial planning and well-being.
I might have thought that after decades of marriage, couples would generally know each other's financial situation pretty well. Is financial infidelity really that common in this older age group? among long-married couples.
That's a logical assumption, isn't it? But it turns out it's often incorrect. Our sources, citing research like a study in the Journal of Consumer Research, found surprisingly similar rates of financial infidelity across all age groups.
Really? Young couples and older couples?
Yeah, from young couples just starting out to older adults who've been married for decades. It doesn't necessarily decrease with age or the length of the marriage. The opportunity and maybe the motivation can still exist.
Wow. And the sources suggest its impact on the relationship and the finances is pretty profound.
It is, hugely. A Harris poll mentioned in our sources found that a staggering 85% of people surveyed reported that financial deception had harmed or negatively affected their relationship.
85%.
Yeah. And for couples who actually got divorced, more than 70% in the U.S. cite money issues as the primary cause of their split. And get this, 52% of people surveyed considered financial deception worse than physical infidelity.
Worse than physical infidelity. That's a really powerful statistic. It just shows how deeply trust is tied to financial transparency in a marriage.
It really highlights that for many people, financial security, honesty about money, it's just as fundamental to the partnership as emotional or physical fidelity. The same survey found that 42% of people admitted to deceiving their spouses financially in some way.
42%.
Yeah, that includes things like hiding purchases or bank statements. And 13% admitted to more serious deceit, like actively lying about how much debt they had or how much money they actually earned.
What are some specific examples? What kinds of financial secrets or deceptions did people confess to in these surveys?
Well, the range of behaviors is pretty wide. Common ones included things like hiding purchases or receipts, that was 24%. Lying about the price they paid for something, 23%.
Huh.
Secretly spending money on children, maybe minor or adult children,
Yeah.
without the spouse knowing, 22%. Lying about selling something for less than they actually got for it, 19%.
Okay.
Then more serious things like secretly withdrawing money from savings, 11%. Opening a secret credit card, another 11%. Actively covering up significant debt, 7%. And even hiding a raise or a bonus from their spouse, 4%.
Wow. Some of those are pretty significant betrayals of financial trust. What makes discovering financial infidelity uniquely damaging or challenging in the context of a gray divorce compared to maybe younger couples finding this out?
It's really the combination of the financial damage itself, which is bad enough happening right when the overall marital estate is being divided, plus that limited time available for recovery at an older age. It creates a sort of perfect storm.
So,
Well, undisclosed debts, hidden bills, years of secret overspending, maybe secret transfers of assets out of the marital pot. All of this causes substantial economic damage that directly reduces the assets available for division in the divorce.
right, less pie to split.
Exactly.
Yeah.
And beyond the numbers, it leads to profound emotional upheaval. It shatters a spouse's long-held expectations for what their retirement lifestyle and financial security would look like. The trust is just gone.
And like we talked about earlier, unlike younger adults, you can't just easily go out and earn back the money that was hidden or squandered.
Precisely. That limited window to earn back lost wealth or generate new income at an older age means the financial hole created by the infidelity is much, much harder, maybe even impossible to fill before retirement. Furthermore, just being older, maybe facing the prospect of living alone for the first time in decades, maybe having limited prior experience managing finances independently, or dealing with the emotional toll of the divorce itself and potential depression. All of that can make navigating the aftermath of discovering financial infidelity even more difficult and overwhelming.
The sources specifically mentioned the vulnerability of older single women here, didn't they?
Yes, it's often a compounding factor. Many older single women already face significant financial insecurity, even without infidelity. They might have relatively low Social Security benefits based on their own work history.
Right.
A significant portion, the sources mentioned, about 20% already rely on public benefits and live in poverty. So discovering substantial hidden debt or finding out assets were squandered due to financial infidelity can push them into even more dire financial straits, making the already difficult consequences of gray divorce even worse.
So recognizing the signs early, or at least during the divorce process, seems critical. What are some red flags people should watch out for if they suspect financial infidelity might be happening?
Yeah, there are definitely warning signs people should be aware of. Be wary of excuses for unusual or irrational money behavior, maybe sudden, uncharacteristic stinginess, or equally sudden, excessive generosity that doesn't make sense.
Okay.
Look for secretive shopping habits, hiding receipts, hiding packages that arrive. Doctoring financial documents is a huge red flag. Things like forging signatures, hiding bank or credit card statements, maybe creating false records.
Wow.
Secretly moving or transferring assets, even if it's to adult children or into trusts, without discussion. Unusual and repeated large cash withdrawals from ATMs or bank accounts. Changing online banking passwords without telling you, or suddenly having financial statements mailed to a separate P.O. box or a different email address to prevent you from seeing them. Fundamentally, any consistent pattern of concealing financial transactions or information is a major red flag that something's likely amiss.
If you see these kinds of red flags, what should you do immediately to protect yourself, especially if a divorce might be on the horizon?
Our sources strongly advise taking immediate action. Don't wait or delay out of fear or hope it will just resolve itself. It usually doesn't.
Okay.
First step, consult with a qualified family law attorney, ideally one with experience in complex financial matters and divorce, or consult with a certified divorce financial analyst, a CDFA. They specialize in the financial aspects of divorce.
Get professional help fast.
Yes. They can guide you on the necessary steps. This often includes vigilantly monitoring all joint bank accounts and credit card accounts, know what's coming in and going out, secure your online access and passwords if you haven't already, and critically, start obtaining historical copies of financial statements.
How far back?
As far back as your attorney or CDFA recommends, often several years. Bank statements, credit card bills, investment account statements, loan documents. This is crucial for tracing assets, identifying hidden accounts, and understanding spending patterns. You should also obtain credit reports from all three major credit bureaus, Equifax, Experian, TransUnion, for both yourself and your spouse. This can help uncover any hidden accounts or debts open solely in one name that you weren't aware of.
Good idea.
Your advisors can help you be realistic about what assets or funds might actually be recoverable. Sometimes money spent is just gone. But the most important thing is to follow their guidance closely, to protect your financial future and make informed decisions during the divorce process. And it's worth noting, sadly, that surveys show very few partners find out about financial infidelity because their spouse confesses.
Really?
Yeah, only about 8% in one study found out via confession, which really reinforces the need for proactive investigation if you have serious suspicions, rather than just waiting for them to tell you.
That's pretty sobering advice. Financial infidelity clearly adds this incredibly difficult layer of emotional and economic damage that's particularly hard to overcome when divorcing later in life.
It really does. It requires vigilance and absolutely requires professional help to navigate the fallout effectively.
Okay, let's move to another major financial challenge in gray divorce. Healthcare. This seems huge. Losing spousal coverage or having to find individual insurance, especially when you're over 50, but maybe not yet 65 for Medicare, can be incredibly expensive and complex.
Oh, absolutely. Healthcare is a critical concern for all older adults, of course, but it becomes front and center.
Yeah.
And often a major financial shock for people going through divorce after 50.
Yeah.
The potential costs of health insurance premiums and actual medical care can become a really significant burden when you're transitioning from maybe a shared family plan or employer-sponsored coverage onto individual plans.
What's the absolute first step someone should take regarding healthcare when they know a gray divorce is happening, or likely?
Our sources really emphasize acting immediately. Don't wait.
Yeah.
As soon as divorce is even contemplated or initiated, start taking steps to understand your current coverage situation and begin exploring alternatives. If you are currently covered under your spouse's employer plan and you're concerned they might try to drop you from coverage prematurely before the divorce is final, you need to inform your attorney immediately.
Why?
So the attorney can request temporary court orders that require your spouse to maintain your health insurance coverage during the divorce proceedings. That's really important protection. And just researching private insurance options, understanding the marketplace, it takes time. So start exploring those options early. Don't wait until you lose coverage.
Now, if you happen to have your own job with its own health insurance, that's obviously a big advantage.
It is. If you're employed and have access to your own employer-sponsored group health coverage, you're in a much stronger position, obviously. But if you were covered by your spouse's employer plan, then COBRA is often the critical next step, at least initially.
Okay, let's talk about individual health insurance plans first. For those who don't have employer coverage or maybe after COBRA runs out, what are the options generally like in the individual market?
Well, the individual health insurance market offers various types of plans. You've got your PPOs, Preferred provider organizations, HMOs, health maintenance organizations, sometimes catastrophic plans, which have very high deductibles but lower premiums.
Right.
And occasionally you might see mini med plans, though those offer very limited benefits. The costs and the level of coverage vary enormously.
Yeah.
Plans with broad networks of doctors and hospitals and lower out-of-pocket costs like deductibles and copays will naturally have significantly higher monthly premiums. You can typically purchase these plans through insurance agents or brokers, directly from insurance company websites, sometimes through the ACA marketplace, healthcare.gov, or maybe through mass purchasing groups like AARP.
How do you compare them? It seems overwhelming.
It can be. It's really essential to work with someone knowledgeable, like a good broker, to compare plans of the same type, like compare PPOs to PPOs, with comparable benefits. You need to focus on understanding the key terms: the deductible, how much you pay before insurance kicks in, the coinsurance or copays, your share of costs after the deductible, the out-of-pocket maximum, and exactly what services are considered covered expenses versus excluded.
So it's basically that trade-off. Pay more per month for lower costs when you need care, or pay less per month but face potentially high bills if you get sick.
That's the fundamental trade-off, yes. Higher deductibles or copays usually mean lower monthly premiums, but you take on more financial risk if you end up needing significant medical care.
Once you get an individual policy, can the insurance company just cancel it on you later if you get sick?
Generally, under current law, standard individual health insurance policies that are ACA compliant are not arbitrarily cancelable just because you get sick. However, they can be terminated for specific reasons, like if you fail to pay your premiums. If you provided false information on your application, material misrepresentation, or sometimes if the insurer decides to exit that particular market or eliminate that specific plan benefit for everyone enrolled, the sources recommend looking for policies that are guaranteed renewable, which offers the most security, though they might be more expensive. At a minimum, look for conditionally renewable policies where termination isn't based just on your individual health status.
What about health savings accounts, HSAs? Can those help manage medical costs?
Yes, HSAs can be a great tool if you're eligible. They are tax-advantaged savings accounts you can use to save money specifically for qualified medical expenses.
How do they work?
Contributions you make are tax-deductible, the money in the account goes tax-free, and withdrawals you make to pay for qualified medical costs are also tax-free. It's a triple tax advantage.
Nice. Are there limits?
Yes, there are annual contribution limits. For 2025, the limit is $3,000 for self-only coverage, plus there's an additional $1,000 catch-up contribution allowed if you're age 55 or older. But there's a catch. You can only contribute to an HSA if you are enrolled in a qualifying high-deductible health plan, HDHP.
Ah, okay. You need the high deductible plan first. Now back to COBRA. You said that's really important if you were on your spouse's work plan. Tell us more about that.
Right. COBRA is often the most common way people maintain their existing health coverage immediately after a divorce, at least for a while. It's a federal law, stands for Consolidated Omnibus Budget Reconciliation Act.
Okay.
It allows eligible dependents, they call them qualified beneficiaries, which includes a divorcing spouse, to continue their coverage under the spouse's employer-sponsored group health plan after a qualifying event like divorce or legal separation occurs.
Who does COBRA apply to? Which employers?
Generally, it applies to private sector employers with 20 or more employees, as well as most union health plans and state and local government plans. Federal employees and former military spouses have similar but slightly different continuation coverage rights under separate laws, like TRICARE continuation for military. COBRA coverage can typically provide continuation for up to 36 months after a divorce.
36 months, so 3 years. That's significant. How do you make sure you actually get that COBRA coverage after a divorce? Is it automatic?
No, it's not automatic, and this is critical. You need to act fast. The qualified beneficiary, meaning you, the divorcing spouse, must notify the health plan administrator in writing within 60 days of the date the divorce or legal separation becomes final.
60 days. That's a hard deadline.
Yes, that 60-day notification deadline is critical. If you miss it, you generally lose your COBRA rights permanently. It's really wise to contact the employer's HR department or the plan administrator early in the divorce process just to get information about COBRA costs, the notification procedure, and to make sure they have your current mailing address so you receive the official COBRA election notice once the divorce is finalized and you've notified them.
Okay. What's the cost and the coverage like under COBRA? Is it the same insurance?
The coverage itself under COBRA is exactly the same as the coverage received by active employees and their dependents under that employer's group plan. So you keep the same network, same benefits. However, the cost responsibility shifts entirely to you.
So no more employer contribution.
Exactly. You have to pay the full premium for the coverage yourself. Plus, the employer is allowed to charge you a 2% administrative fee. So you typically pay 102% of the total cost of the plan.
Ouch. That could be a lot more expensive than what was being paid before.
Oh, definitely. COBRA premiums are often significantly higher than what you were used to paying as an employee contribution while married, because that employer subsidy is gone. The first premium payment is usually due within 45 days after you formally elect COBRA coverage.
And you said COBRA lasts up to 36 months. Can it end earlier?
Yes, it typically ends after 36 months from the date of the qualifying event, the divorce. But it can also end earlier for several reasons. If you fail to pay your premiums on time,
Okay.
if the employer stops offering any group health plan to all its employees, if you become covered under another group health plan, like through a new job,
Right.
with some limited exceptions, or if you become eligible for Medicare after you've already elected COBRA.
Okay, so after those 36 months of COBRA are up and maybe you're still not 65 for Medicare, are there any other options to continue coverage, especially if you've developed health problems?
Well, some employer group plans offer something called a conversion coverage option.
Conversion coverage.
Yeah. After your 36 months of COBRA eligibility end, you may have the right under the plan terms or state law to convert your group coverage into an individual health insurance policy issued by the same insurance carrier.
Without a health screening.
Usually, yes. It's typically offered without requiring a medical evaluation or underwriting. This can be incredibly valuable if you've developed pre-existing medical conditions during the COBRA period that might make it hard to qualify for a standard individual plan. However, the premiums for these conversion policies are usually very, very high, often much higher than even standard individual plan premiums. But it's an option to explore if you need guaranteed coverage.
Okay. The sources also mentioned HIPAA portability. What's that about?
Yeah, HIPAA, the Health Insurance Portability and Accountability Act of 1996, included some provisions designed to help people maintain coverage when moving between health plans.
Oh.
Essentially, if you were covered under a group plan, like through work or COBRA, and maintained continuous coverage without a significant break, generally defined as 63 days or more, those state laws might offer longer grace periods.
Okay. Then HIPAA generally provides you with rights to purchase individual or other group coverage without being subject to exclusions for pre-existing medical conditions. You often need to fully exhaust your COBRA rights before HIPAA guarantees your access to individual coverage without pre-existing condition limitations. But it provides another layer of protection for continuous coverage.
Okay. Are there any other safety nets out there for people who might have trouble getting individual insurance due to health issues, maybe before the ACA fully kicked in or if issues arise?
Some states historically operated state insurance risk pools. These were designed as sort of a temporary safety net for individuals who could technically afford private insurance premiums, but were denied coverage in the individual market due to pre-existing health conditions.
Okay. Eligibility rules and availability varied a lot by state, and the premiums in these risk pools were typically quite high. With the implementation of the Affordable Care Act, ACA, which broadly prohibited insurers from denying coverage or charging higher premiums based on pre-existing conditions in the individual market, the role of these state risk pools has significantly changed or diminished. Access to individual plans is now generally available through the ACA marketplaces.
And then, of course, there's Medicare once you turn 65.
Yes, Medicare is the big one. It's the federal health insurance program primarily for people aged 65 and older, as well as for some younger people with certain disabilities. It's obviously a crucial part of retirement healthcare planning.
But it doesn't cover everything, right?
No, definitely not. It's really important for listeners to understand that Medicare does not cover all healthcare costs or services. For example, it generally doesn't cover routine vision or dental care, hearing aids, or, importantly, most long-term care services like nursing home stays or assisted living.
So you need something else.
Most people on Medicare find they need some form of supplemental coverage to help fill those gaps and cover costs like Medicare's deductibles and copays. This usually means purchasing a private Medigap Medicare supplement policy or enrolling in a Medicare Advantage plan, Part C, which are private plans that contract with Medicare to provide benefits.
Okay. And Medicaid is the safety net for people with very low income and assets.
Correct. Medicaid is a separate program. It's a joint federal and state program that provides health coverage to eligible low-income adults, children, pregnant women, elderly adults, and people with disabilities. Eligibility rules are primarily set by each state and can vary significantly. It's a needs-based program, completely distinct from Medicare or insurance you buy based on employment or in the individual market.
So it's clear that navigating healthcare after a great divorce, especially in those years between losing spousal coverage and becoming eligible for Medicare at 65, is a really significant challenge. It involves understanding all these options, COBRA, the individual market, maybe conversion policies, all while facing potentially much higher costs than before.
It absolutely demands immediate attention when divorce is happening, careful research into the options available in your specific situation, and often getting professional guidance from an insurance broker or financial advisor to ensure you maintain continuous, adequate health coverage without breaking the bank. It's a huge piece of the financial puzzle.
Okay, pulling all of this together, I mean, the emotional pain, the often severe financial consequences we talked about, figuring out Social Security nuances, dividing complex retirement assets correctly, dealing with the potential devastation of financial infidelity, and then securing affordable health care. It just sounds incredibly daunting and overwhelming for someone going through a great divorce. What overarching advice do our sources offer for just navigating this incredibly difficult process and trying to ensure best possible outcome financially?
Well, first, I think the sources would say to acknowledge the reality of the pain, both the emotional pain and the financial pain. Divorce is hard at any age, but it does have these extra layers of difficulty later in life when financial options and recovery time are more limited.
And despite that emotional pain, taking the high road, as they say, seems really crucial for your long-term financial future, doesn't it?
It's absolutely vital. While anger, frustration, sadness, those are all completely natural emotions during a divorce, focusing on making long-term, rational financial decisions rather than reacting based on short-term, emotionally charged feelings is key.
Like fighting over the furniture.
Exactly. Fighting over small assets out of spite, for instance, can easily end up costing you exponentially more in legal fees than the actual value of the asset you're fighting over. I think one source mentioned an anecdote about a couple spending tens of thousands in legal fees fighting over a chainsaw.
Wow. Point taken.
Contentious, drawn-out divorces are just enormously expensive, and they end up draining the very marital estate, the very pot of money that you're trying to divide fairly in the first place.
Mediation is often suggested as a way to try and avoid that kind of costly conflict, right?
Yeah.
Yes, absolutely. Our sources suggest that many couples, even those with complex finances, can successfully resolve their divorce disputes, including all the financial matters, through mediation.
How does that work?
You work with a neutral third-party mediator who helps the couple communicate, identify the issues, explore options, and hopefully reach mutually agreeable solutions on their own terms. It can be significantly faster and far, far less expensive than battling it out in court through litigation.
And you absolutely shouldn't try to figure out all these complex financial issues, Social Security, QDROs, taxes, all by yourself.
Oh, absolutely not. That's a recipe for disaster.
Uh,
Building a professional team is essential. You'll need a family law attorney who specializes in divorce for the legal process itself. But crucially, our sources stress bringing in a financial expert early in the process.
yeah. Like,
Someone like a financial planner, or even better, a certified divorce financial analyst, CDFA, who is specifically trained in the financial issues of divorce. They are indispensable.
what do they do?
They help you understand the long-term financial implications of different settlement options. They help you create a realistic budget based on your new single-income situation. They help you develop a new retirement plan, likely with reduced assets. And they help you understand the complex tax consequences of dividing different types of assets, like realizing capital gains if you sell the house versus tax-free transfers of IRAs or QDRO funds. They look at the whole financial picture, present and future.
Okay. In addition to the obvious things like bank accounts and retirement plans, what about other, maybe less obvious assets people should make sure are addressed?
Yeah, our sources recommend explicitly checking ownership and, maybe even more importantly, beneficiary designations on assets like 529 college savings plans set up for kids or grandkids,
Oh, good one.
life insurance policies, annuities, and any trusts that might exist. You need to ensure that your divorce agreement clearly addresses who owns these assets going forward and, critically, protects the intended beneficiaries.
Right. You don't want a life insurance payout meant for your kids accidentally going to a former spouse's new family because you forgot to change the beneficiary form.
Exactly that. It happens more often than you'd think. Update those beneficiaries.
Taking some time for planning, if that's even possible during a divorce, could also make a difference.
Yes. If your personal circumstances and the legal process allow for it, sometimes things move very quickly. But, if possible, considering whether delaying the final divorce date slightly could give you valuable time to improve your financial position or skills is worth exploring with your attorney.
Like what?
Could you potentially re-enter the workforce if you weren't working? Could you get a quick certification or degree to boost your future earning power? Could you build up even a small emergency fund before you're fully on your own? This isn't always feasible, obviously, but if there's an opportunity, using that time strategically to prepare for financial independence can be helpful.
And consulting with specialists for very specific, complex interactions, like maybe how benefits or taxes interact.
Exactly. Sometimes you run into really niche issues, like how might receiving alimony payments affect your eligibility for Social Security disability benefits? Or what are the highly specific tax rules related to dividing stock options granted during the marriage? For those kinds of complex, overlapping questions, you might need a brief consultation with a CPA who specializes in divorce taxation, or perhaps an elder law attorney, as one source example highlighted. Don't just guess on those nuanced points, get expert advice.
Finally, the sources offer a bit of perspective on the decision to divorce itself, even with all these financial challenges.
Yeah, it's an important point. While staying married, maybe living separate lives under the same roof, what some people call separate peace, might seem like the cheapest option financially because you avoid the immediate costs of setting up two households and dividing assets. The sources also remind us that the non-financial benefits of divorce can be immense and shouldn't be discounted. Gaining freedom, achieving peace of mind, escaping an unhappy or perhaps even abusive situation, that can be truly priceless, particularly when you're thinking about the quality of your later years. It's not purely a financial calculation. Personal well-being is a huge factor in the decision.
This has been a really deep dive into the unique and often difficult financial challenges of gray divorce.
It really has, and it's clear that gray divorce is a rapidly growing reality in the U.S. and many other countries. The financial consequences, especially as we've seen for older women, are profound and often quite devastating if not handled carefully.
So, understanding your potential rights related to Social Security benefits, whether from a living or deceased ex-spouse, grappling with those intricate legal and administrative complexities of dividing retirement assets, using the correct orders like QDROs, proactively tackling the puzzle of securing adequate and affordable health care, and being vigilant against and prepared for the potential impact of financial infidelity. All these seem like absolutely critical steps for anyone facing or even just contemplating a late-life divorce.
Absolutely. And as we've really seen throughout this deep dive, trying to navigate this incredibly complex financial landscape without assembling a strong professional team, including a Guild family law attorney and a knowledgeable financial expert like a CDFA. It's not just difficult, it's highly likely to lead to very costly mistakes. Mistakes that can seriously jeopardize your financial security throughout retirement. Professional guidance here really is a necessity, not a luxury.
It really underscores how this major life event, which might feel like an unding in many ways, actually requires immediate, forward-looking, and pretty sophisticated financial planning to build a new beginning on solid ground. So bringing this all to a close, what's the bigger picture thought we should maybe leave our listeners with?
Well, if we sort of connect this trend of gray divorce to the broader societal landscape, as the number of these silver splitters continues its rapid ascent, this isn't just affecting individual families' balance sheets, it's fundamentally reshaping what retirement looks like for a growing segment of our population.
Yep.
And that raises some really important questions for all of us to consider. What are the wider implications for society? Thinking about the changing housing needs for older single individuals, the increased demand we're likely to see on social support systems and elder care services, and maybe most importantly, how do we collectively work towards ensuring the economic security of an aging population that is increasingly facing retirement with reduced individual wealth and higher independent living expenses due to divorce? This trend isn't just individual, it's truly transforming the financial experience of later life in America.